Line up over here if you want to speak for or against, and keep the list separately, if you would, please. And initially, I'm going to ask Chad if he would to lead us in a prayer.
Heavenly Father, God, we thank you for this day. We thank you for the leadership of this state and the people in it and all that you've blessed us with. God, we just pray that this meeting be conducted in a manner that's glorifying and honoring to you. We ask these things in your name. Amen.
Amen. Thank you. And in the beginning here, we'll have Chairman Hamilton to give us a summary of the bill, and he's going to do it from his seat since we're off today.
Thank you, Chairman Pruitt. It's great to be here. 2015, hard to imagine that. Let me just tell you a little posture here. We're going to have a subcommittee hearing here first, and we will have a full committee organizational meeting, and depending on the will of the committee, beyond that afterwards. And so I appreciate everybody staying an extra day. And then in the full committee, we'll announce the new members at that time. But since I had to be down here for the transportation subcommittee, I thought I'd invite the rest of y'all here. So thank you for being here. And this is a committee day, and y'all know what that means. So, all right, House Bill 117. House Bill 117, and I'm going to make sure we have the right LC. This is LC 362662ER. And let me tell you what the bill does. Section 1 and 2 basically deals, is a result of a Harrison case back in 2002, and it deals with a term called most recent employer. And so for the purpose of claims and is also as modifiers, we're going to change the definition, and we're going to make it so that the most recent employer is really the most recent employer. Under current law, what ends up happening is it's a complicated process to determine who technically the most recent employer is determined. There was a term in there, last liable employer, and so this really just clarifies in a code, and it's really in Section 1 and 2 it does that. There's also some language in Section 5 that helps clarify that. So what this means is the shift is that if an employee wants to file a claim, a claimant becomes a claimant, they can do so. And then even if they've only worked for that new employer only one day, then that is their most recent employer. That's basically what the code does. It basically streamlines and makes the process much more clear. It allows the Department of Labor to have some very specific rules to determine that with. It makes no difference to the claimant. There's no impact on the claimant. It just simply clarifies who the most recent employer is. And so that's really the purpose of Section 1, 2, and 5. Section 3, actually it's Section 3 and Section 6 deals with statute of limitations. There was an AG opinion, currently code, there's no statute of limitation, an AG opinion that established it at 4 years. What this does, this seeks to take the statute of limitations from 4 years to 7 years. Now let me explain to you the real purpose behind that. The purpose behind that is that in some of these cases it takes 2 to 3 years just to adjudicate the claim. It takes a long process to go through this. So if there is a claim going on, then it's very possible that that claim doesn't start until year 2 and it goes beyond 4 years. Then at the end of that 4-year period, the statute of limitations ends, and so it ends at that particular point. For those claimants, the employees, you might think, well, that's bad. So these cases are typically not, you're looking back 7 years to go try to find fraud or overpayment or underpayment. These are typically cases that it just takes longer than 4 years for that process to end. So if a claimant, for example, is 3 years into the process and they want to work out a payment plan so that payment plan lasts, right now they're limited to forcing it to the end of 4 years. And so, whereas the claimant, it might be more financially feasible for that plan to last 2 years or 3 years. This gives them the ability to extend that up to 7 years. So Section 3 deals with companies in the Department of Labor. So this is how the Department of Labor, if a company wants to come to the Department of Labor and say we overpaid, then part of that process would be extended to 7 years. And in Section 6, it deals with the Department of Labor dealing with the claimant. It extends it from 4 to 7 years. And then Section 4. Section 4, there is really kind of almost a timing issue to a certain degree. There's a lot of press right now on family violence. There's some high-profile examples of that. And so what Section 4 does is it creates an exception for unemployment claims, and it deals with family violence. And so if you're a victim of family violence, then it allows a provision. You can go through a process to certify. It's not easy. You can't just say, hey, I'm a victim of family violence, but there's a process that you go to. And it stems from the fact that there's shelters out there that are helping both men and women and children, I guess, but men and women we're dealing with here, where part of the requirement is of these shelters is that you do not have a job. You might think that sounds kind of weird. Well, the simple reality is if you're a victim of family violence, one of the things that you have to realize is if that person that is creating that violence, if they know where you're employed, guess what they get to do? They get to go find you. And as an employer, I would not like this in my workplace, but it certainly, I don't want to be worried that someone's going to come into my workplace to potentially harm one of my employees. And so we've set up some very specific criteria on how you would make that claim. The second part of that is, as an employer, we've said we're not going to punish the employer by allowing the charge to go to that employer, so the charge will go back to the trust fund. So basically that would be spread across the entire population. That's basically what the bill does. And there's one final section, Section 7. Now this is one that we tried, it's been tried for several years in a number of different places, but it deals with the identification in the affidavit that you have to complete when you file an unemployment claim. When I first heard about this, I'll tell you my first reaction, because some of you may have that same reaction, so I'll share mine, and that is, why would we not want to make, I'll use that term, an employee that was terminated, why would we not want to make them go to an unemployment office to fill out the application? To me, that was from an employer standpoint, I'm thinking, gee, we're letting that person off. Well, let me approach it from the other, I've since learned, let me approach it from the other perspective. As many of you know, we continually try to create a more efficient government. We continue to try to control costs and become more efficient. So from a practical standpoint, what happens is the only reason they go to that office, because they can do everything else online, the only reason they go to that office is to sign a document, show identification, and start a paper trail acknowledging and sign an affidavit that all this information is true. That's my understanding of the process, which means that they have to go to a physical facility, they have to wait to be waited on, they have to talk to someone, they have to go through this, they create a paper file, that paper file is put someplace else, and then they turn around and scan the file. And so it's a relatively labor-intensive process, especially if you add the brick and mortar. What this provision does is it says the new Georgia driver's license that's required effective July 1st, 2012. I went and got mine this past year. That new if you have that driver's license, then you have the option, it's not mandatory, but you have the option of going online and handling the affidavit portion online, and you put in your Social Security number, relative information, as well as your Georgia driver's license of this 2012. It then pings over to DDS. DDS verifies the match of all that information and sends it back to the Department of Labor. And that's really all it does. It basically allows you to sign that affidavit. And by doing so, the person does not have to go take up staff time in the office. They also do not create a paper trail. Everything at that point is electronic and moves forth. And so that's what Section 7 does. And I know that we have some Department of Labor people. We have some other people who want to testify. I guess what I'd first do, though, is see if any of the committee members would like to ask me any questions, and I may or may not have the answer, and I may have to rely on someone. I'm not sitting out there, but I would ask probably the Department of Labor to come down and if I need their assistance. So that, Mr. Chairman, I'll yield for questions if there are any.
You do have one question. I can't tell what number it is. I mean, 24. Oh, that's you? Okay.
Thanks, Mr. Chairman.
Mm-hmm.
I've got several questions. First thing, start with the end.
Is your mic on down there?
If you press the button, I got the red light on.
Well, you're number 24. You're pressed, so you should be. That'd be better. Nobody can hear you.
Is that better?
That's a lot better. Thank you.
All right. I like the idea in allowing an employee or former employee to use online services. At the time of separation, employer is required to give them the state form, and then we fill out, and it has all the information on not only our tax account, but the reason for the dismissal or termination or separation. To make, in the process someplace, that's supposed to be taken to the unemployment office when they file as part of the process. Is that something that we need to put in here to amend to allow that an online version, that we could fill that out online as well as a paper copy?
Let me appreciate the question, and let me respond what I know, and I'm going to ask the Department of Labor to go ahead and come down to assist me in this. First of all, unless I'm mistaken, you're not required to fill out a separation notice unless asked for by the employee. I know in my particular case we have some that do ask for it and some that do not. I'm not sure what the use of that separation notice is done by the Department of Labor, but I'm sure that Learned Counsel Mitchell will certainly be able to answer that.
Can you turn your mic on there?
Can you hear me? The DOL 800 is what you're referring to, and I don't think you necessarily need to change this bill for that. That's something that, trust me, if we can do it so you can report it that way and file it that way, then we're more than glad to move in that direction. It would be great if we could have the employers all present them. A lot of them don't. There's no enforcement power on that end, so it's just a requirement that they can and may choose not to. A lot of our claims do come in without it, and your suggestion is a good one, and I'll be glad to talk to the department and see if we can't move in that direction if we can pull it off.
All right. Thank you. Mr. Chairman, I got a few other questions to make sure I understand this right. As I read through this and what you explained, there is absolutely nothing in here that would be a negative impact to an employee or former employee on getting unemployment.
That is correct, based on what I said. Matter of fact, it's really, this is more, the total bill is to help from an efficiency of processing claims, as well as a clarification of who's going to be the most or the most recent one, and then there's the process of the family violence.
Mm. And then finally the part that that I've dealt with the most. If I have an employee that would voluntarily resign, has another job, he or she would typically not be eligible for unemployment because they are not unemployed through no fault of their own. But
this does not change that at all.
The new employer, it doesn't work out, whatever reason, they just weren't qualified for the job to make them eligible. But instead of going back against my account, it's going to go to the most recent or to the trust.
That is exactly right. Matter of fact, we had great discussions over time on that very thing, trying to determine if there was any need or necessity for putting probational periods, for doing things. And at the end of the day, this is how I would say it as a business owner and also a staffing company owner. I would say, bless you, make sure if you're going to hire an employee that you really want to hire them, because once you've hired them, they are your employee. from a fiduciary standpoint, from all the other liability standpoint, they are your employees. So once you hire them, then you own the possibility of future, whether it be workers' compensation, unemployment, all those type of things. If they're an employee of yours, then you're responsible for them. That's right. It happens day one, and your account will be charged accordingly.
All right. Thank you. That's all the questions I had.
I have a question referring to that, if you don't mind. So, a lot of people in the process now, I think, probably do a 90-day trial period, and with an understanding that for any reason, whether you're happy or the employer is unhappy or employee is unhappy, they can leave, and that does not go against your unemployment. But you're saying in this case that it will?
Well, first of all, there is no provision right now that says during that first 90 days, if you terminate them, that it will not go against your employer.
If they're terminated by will of either one, then it's.
Well, let me clarify.
All right, please do.
The only thing this changes is to whose account will be charged. That's the only thing so presently, if you hire an employee and they work one day and they have met the minimum criteria in a previous workplace. In other words, they've worked, I think it's 10 weeks. They've been charged 10 weeks at the average allowable numbers of minimum wage, not minimum wage, but the average wage benefit. Then they're eligible to receive unemployment. If you hire a person day one that has never worked anywhere, they're not going to receive anything anyway because they've not accrued or earned any unemployment. The only thing this does is says that when you hire that employee, you own that employee's liability from an unemployment standpoint, not any previous employer.
The question is, and maybe I have always misunderstood this, but you saying from day one when you hire them, but if you hire them or not hire them, but you put them on a temporary initially, will that fall back on you as an employer as far as unemployment? I just don't know the answer.
Once again, you can have a probationary period in your company. We work in a right to work state, so you can terminate that employee whether you have a probationary period or not. You just have a policy that allows that. This does not change any of that. I think, let me just, again, I'm trying to make it real simple. All this does is say that when you hire that employee, you own the unemployment liability, whatever it possibly is, when you hire them day one. Now, if they haven't met that threshold, then there is no liability to your potential. Maybe I'm saying it wrong, counsel, but that's, I'm trying to explain it as easy as I possibly can.
If I may?
Yes, please.
You're looking at it from the employer, and as far as whether or not the employee would have a valid claim against your account. This bill doesn't deal with that.
Okay. Whatever it was is what it is.
Yeah.
Okay. Very good. And Representative McLean.
Thank you, Mr. Chairman. I want to just say that maybe Representative Kirby answered, asked for one of my questions, but I do want to the impact. Does this have anything with the filing of the employee as far as when he can file or the length or anything like that?
No.
Okay, good, thank you. And the other question I think I do have is this won't have any effect, any budget change for the employment insurance or trust fund. I mean, I heard you say if the employer didn't go, and then it went to the trust fund.
The only change, I guess you could think, is that should a person successfully file an unemployment claim as a result of the domestic violence provision, that which right now that is not an exception. Okay, so you cannot file unemployment using that exception. You would not receive any benefits. Okay, so what this does is this creates an exception so that if a domestic violence employee proves, it's their responsibility to prove it, If they prove that they're a victim of domestic violence, then that becomes an exception that they can receive unemployment benefits. The only change financially is the fact that normally when you receive unemployment benefits, it's charged against the employer's account.
Mm-hmm.
This will just go to the trust fund, which means it's spread across the thousands of employers out there that pay into that. So that employer, so if I'm a small employer and I have an employee that's a victim of family violence, and y'all correct me if I'm stating this wrong, and that person quits, but they say the reason I quit was because of domestic violence, and they apply in their process showing that, and the Department of Labor grants them domestic violence. Because of that, they give them their benefits. Then the only difference is, instead of that claim coming to my unemployment insurance, my annual cost, it would go to the trust fund. Now, to me, in other words, this is a new benefit to victims, potential victims of, or not potential, it's potentially a new benefit to victims of family violence. We're also giving the employer the benefit of, they're not going to pay for it totally on their own. We're going to spread it around to the rest of the Georgia businesses.
Thank you, Mr. Chairman.
Are there any more questions from the panel? If not, then I think our first speaker is our friend Roy Bowen. Yes, that'll work fine. Either one, whatever's comfortable for you.
Thank you, Mr. Chairman, members of the committee. My name is Roy Bowen with the Georgia Association of Manufacturers. Just want to preface my remarks by thanking this committee for the fine work that they did a couple of years ago in the unemployment insurance reform legislation. You know, we had a tremendous debt that nearly approached $1 billion, and because of your fine work, we're able to pay that debt off, and that makes Georgia an even more attractive place for business investment and job creation, so thank you for that. We'll accept that the representation by the Department of Labor that sections 1, 2, 3, 5, and 6 are really housekeeping in nature and really don't warrant any additional comment by us. I would like, however, to comment on the more substantive changes in section 4 particularly. And with regard to section 4, that deals with the family violence, I really do believe that Chairman Hamilton did an admirable job of dealing with a very serious and sensitive issue in a very responsible way. This very tightly defines family violence and sets reasonable parameters for determining eligibility for benefits for a person voluntarily leaving a job because of family violence, and really I think minimizes the risk of abuse here. We talked about the fact that the employer is not charged. I think that really does reflect the societal nature of this very serious issue. And I would just point out that spouses of military folks who are transferred have the same non-charge provision applied to them. So this is not paving new ground on that score. And I'd also like to emphasize that a person that does voluntarily leave their job because of family violence must be fully engaged in a job search. So I think that's another protection. And finally, the commissioner will be promulgating rules that implement this legislation should it pass, and of course those rules will be subject to public input. As to section 7, as the chairman indicated, we think that this brings administrative efficiency and potential cost savings to the system, and really is a benefit to the claimant as well. So we would support that. So all in all, we think this is a very good bill, and we commend it highly for your favorable consideration. Be happy to answer any questions.
Thank you very much. I do have a question, but it may be more for the chairman, but
yes,
you're welcome to stand there for a second if you like. It just popped into my mind a concern to where if they are part of family violence and they do have to leave their job and they do get the benefits and it's not charged to the employer, how long can they get those benefits, or do they have to be in a process of looking for a job after a period of time, and what's the cutoff point, or does it run the full spectrum of what they normally could do if they lost their job?
Well, let me answer part of that, and I may ask DOL to help me on this, but or Mr. Bowen. But presently, the most benefits that you can under the current system is about 16 to 17 weeks. That's pretty much maximum benefits. And
That's state, right?
Well, that's all there is.
That doesn't count federal.
There is
Oh,
no-
that's right.
no,
There's no
no
federal. Okay,
federal.
okay.
So it's about
Yeah,
16
you're
or
right.
17 weeks
Okay.
maximum.
Okay.
So, you know, if you think of 13 weeks being 3 months, you're talking 4 months probably max, something like that.
Okay. Very
Now,
good. Thank
as
you.
to the, I would like
know if that's-
an answer on, you brought up an interesting point, but on the seeking of employment, you know, can you give me a little thing there? You know, we're, on one hand, we're allowing them to leave there, but at the same time, they have to be able to, on a weekly basis, indicate that they are looking. So can you just speak to that? I'll be very candid with you. I hadn't
That
thought
doesn't
through
really,
that process.
yeah, that doesn't really make sense. You're requiring them to look for a job while you're telling them they can't work, so.
Or is it possible, and yes, is, I mean, in the legislation, we have some very specific parameters on the shelters and that type of thing, but we know that we're going to have to promulgate rules. So would that be one of the rules that would be allowed as part of that exemption? And the commissioner, I know, is not here to answer this, but that may be more of a policy issue.
I think that number one is a policy issue. Number two, what usually occurs is anecdotal, is that if an ex has had problems with his spouse, they would go to the place where they know they work. Then drive around the city looking for them, and they go to where they know they work. That individual would have to do that job, which not only to their safety and the safety of their family, but also the public. That doesn't preclude them from going to someplace else. They would have to show that they're safe. And you raise a very good point, how do you carry that forward? And right now, that's what they have.
Well, that could possibly be a domino effect, because then the next week they find out where they're working and they got to leave that one. And then 2 weeks later they find out where they're working. But anyway, just think about that and see if there is any tweaking that needs to be done.
And if that happens,
Yeah.
that doesn't change from a benefit standpoint.
No, I understand that.
It really,
You're only granted X amount of benefits for a benefit year. And in this case, let's say that's 7 days. That's it.
Okay.
Even if they had that continuously to happen, there's a certain cutoff.
and I guess from and I'll use Mr. Bowen's, I think in thinking that through, and I apologize as the author of this, I really hadn't made that connection, and so I really do want the feedback. But I'm assuming that in that scenario, that would make sense. You're really leaving the employer where this person knows you're employed. It certainly does not preclude you from finding additional employment somewhere else.
My thought would be that employer would say, if you're having family problems, I probably won't hire you.
Well, I'm not sure that that's a legal question to ask in the interview process.
You're
so,
right. Okay. Well, we're getting too deep in the weeds, maybe. All right, thank you.
Thank you,
I
Mr.
appreciate
Chairman,
your
members
time.
of the
And next on our list to speak is Kyle Jackson. Oh, I'm sorry, I missed a question. Was it for Roy or? Okay, come on. I'm great. I'm sorry, I didn't see that. Apologize. Now, be careful, Mr. Mitchell. This is a very sharp guy.
Thank you, Mr. Chairman. And Chairman Hamilton, I think, touched on this, and he may respond to this, but while Mr. Mitchell was up there, I wanted to ask it. Under current law, how long do you need to work at the second employer before a future unemployment event is charged to the second employer's account under current law? 10 times your weekly benefit amount? I was thinking about a matter of time, that it's not judged by time.
$5. So put it, if you happen to be in a profession like an electrician or something, you actually can earn your weekly benefit amount in 2 weeks. You know, get paid a couple $1,000 a week if you're there.
The person that it wouldn't affect, I mean, on the other end would be if someone was working for minimum wage.
And the change we're going to make is going to remove that provision and make it a time provision of basically being hired at the next employer.
Right.
Correct.
Okay.
Once you become an employee, then you also are responsible for the potential liability
Right.
of the unemployment claim.
And this may be a conflict of laws question, I don't know, but being from the Augusta area, we run into Georgia, South Carolina stuff a lot. So I work in Georgia for an employer, and I leave there, and I'm eligible for unemployment, but I do a good job in finding another job. It just happens to be across the river in North Augusta, and then I work there a week, but it doesn't work out for whatever reason. Where's my unemployment claim?
Well, it depends on which state you file in.
Right.
For starters, then you'd have to be basically considered what we call an interstate claim. And then you start sitting down to figure out which one. You'd have to go under those rules and make that determination.
And we have that happen regularly in border state regions. We have provisions to ferret that out.
Yes, sir.
Okay, good. Thank you.
Thank you for the question. Okay. Kyle Jackson.
Good morning, Mr. Chairman, members of the committee. My name is Kyle Jackson. I'm the State Director for NFIB here in Georgia. Appreciate the opportunity to be here with you today. I would echo Mr. Bowen's comments. Kudos to you all as well as to the department for putting us in a much better fiscally sound and responsible place today through your actions. I'm here today to support proposed legislation, House Bill 117. We view it as another step further to modernize the Department of Labor and Georgia's unemployment system, and favorably ask for your favorable consideration. We'll be happy to answer any questions if there are any.
Any questions from the panel? Well, thank you very much for coming, and that was our last person that has signed up to speak, and I'll ask you, Mr. Chairman, do you have further comments you'd like to make before we bring it to a vote?
No, I think that we've tried to address it. Let me be very clear about this. I want to commend the Department of Labor. They came to me early in the process, I think, and we've worked on this, and I will let you know that this bill is comprehensive or non-comprehensive as you may find it. It's a smaller bill than what we originally started with, and so we went through a very thorough process to get to where we thought this was done, and I appreciate their willingness to start before the process so that we could be mindful. Having said that, that allows us on day 11 or 12, or well, we're not even in session today, but gives us the ability to do this. And so my intention, my posture, was to bring it forth to this subcommittee, and I would just answer any questions. If not, I would urge passage of it.
Then we'll ask for a motion.
Yes, Mr. Chair, motion to do pass subcommittee and be presented to the full committee.
I've got a first and a second. Thank you very much. And all in favor say aye. Aye. All opposed? None. So we have a unanimous and do pass recommendation. And thank you, Mr. Chairman. Great job. And thank you, Labor Department, for being here and continuing to work on this very complicated issue of labor on a continuing basis. Meeting adjourned. Well, this meeting is adjourned.